Sure, shut up. If you ask me a question, I can't answer while you're talking.
Okay. Now I have.
Sir, get your ass in the chair or leave and I'll issue a bench warrant. You're not running the courtroom. I am. If you want to have an exam today, get your ass in the chair.
Another threat. Wow.
You're probably going to hear more than one. Sir, you are in contempt of court. That's a $100 fine. Speak again when it's not your turn and I'll continue to up the ante. I don't give a shit if you object. Is it clear what I said? I'm in charge. I get to do shit you don't get to do. It's part of the black robe, okay? That's just the way it works. My courtroom, I get to decide how it's run. Have you ever had a grilled cheese?
If it was different.
Have you ever had a grilled cheese?
If it was different, why would it have two
Have you ever had a grilled cheese?
Other issues as well.
You're in contempt of court. Put him in jail.
All right, guys. Today we've got one of the most disrespectful sovereign citizens we've ever seen on this channel. This dude has the biggest ego and straight up refuses to answer any of Judge Oakley's questions. And let's be real, Judge Oakley is the best judge on YouTube. No debate. It's honestly wild how this guy thinks he can just ignore the law and talk circles around the judge. But let me tell you, Judge Oakley is not having it. He shuts this guy down effortlessly, handling him like a total pro. Let me know what you guys think while watching. Did Judge Oakley handle this idiot perfectly? Or do you think he could have been even tougher? Rate his performance 1 through 10 in the comments. But for now, let's go ahead and dive into one of the most intense court hearings I've ever seen.
You're a defendant. Sit at the defendant's chair.
I'm not defendant. I'm sorry.
Judge, if I may try to help explain.
Try.
I'll try. Mr. Michaud is a sovereign citizen, and
No, I object. I'm not a sovereign citizen.
All right, sir, don't speak.
I maybe am not phrasing that correctly.
Don't speak until I ask you to speak.
But there is a difference between Frank Michaud, or I think it is Mr. Michaud's assertion that there is a difference between the natural person, Mr. Frank Michaud, and the sort of legal entity.
I don't recognize that.
And that's what I've prepared Mr. Michaud for that.
Sir, you're a defendant in my courtroom. Either I issue a bench warrant because you haven't appeared, or you come up here and sit in the chair and we proceed.
All right, so you're threatening me to.
Absolutely, I'm threatening you. Either you're here today or you're not. If you're not here today, a bench warrant will issue. If you're here today, I need you in the chair so we can proceed with the proceeding that's scheduled, which is a preliminary exam.
And if I may, I have advised Mr. Michaud that the courts receive objections all the time, or rule objections that are preserved on the record. If he has,
He can appeal me. I'll let you build whatever record you want to build, Mr. Michaud.
Are we on record?
Yes.
Are you on your oath to the Constitution?
Hold on. Are you picking him up? That's one of the reasons I want you up here is there's a microphone here.
I'll speak loud.
Are you picking him up?
Yes.
Go ahead.
Are you honoring your oath to the Constitution today?
Pardon me?
Are you honoring your oath to the Constitution? You have an oath to the
I didn't swear an oath to the Constitution.
You have.
I took an oath that said I would follow the Constitution.
To not uphold the Constitution?
Yes, follow the Constitution.
So you are upholding your oath to the Constitution?
Yes.
Thank you. I accept your oath. Thank you. Okay. Now I have.
Sir, get your ass in the chair or leave and I'll issue a bench warrant. You're not running the courtroom. I am. If you want to have an exam today, get your ass in the chair. That's the way it works.
I reserve all my rights as
I would have nothing less.
I reserve all rights.
Now, are you representing yourself today?
I'm presenting myself.
That's not what I asked you. Are you representing yourself, or is this gentleman going to be your lawyer for today's proceeding?
I will be presenting myself today.
may
All right, so that's a no. You don't want him to represent you?
No, for the record, he's not my lawyer. I don't have an attorney. I present myself.
Okay.
Judge, what I've recommended to Mr. Michaud is that he has a jurisdictional argument that he wants to make, and that, pending Your Honor's ruling on that jurisdictional issue, I have prepared to conduct a preliminary exam.
Okay.
And could be, available if he wanted to ask me to do that at the correct time.
So you want to represent yourself for that jurisdictional argument, and if I rule against you, then perhaps you want him to represent you? Is that what I'm hearing?
No, that's not what you're hearing.
All right, so you don't want him at all under any circumstance?
No, I don't need an attorney for the record.
Okay.
So with that being said.
Well, hold on. You can stick around if you want to, but I'm not going to obligate you to stay.
I understand, Judge. I'm definitely going to stay.
That's fine. All right.
So today,
You have a jurisdictional argument you want to make?
what I served notice.
Sir,
on
it's a yes or no. Do you have a jurisdictional argument you'd like to make today?
I have a
Yes or
multiple-
no?
This is the biggest issue with sovereign citizens. They act like they've cracked some secret legal code when in reality, all they're doing is making fools of themselves. It's like they think they're starring in some budget courtroom drama where dodging questions and talking in circles somehow wins the case. And honestly, it's so unnecessary. If they just showed a tiny bit of respect to the judge, maybe, just maybe, they wouldn't get absolutely steamrolled every single time. Like, I'm not saying sovereign citizens are the worst people ever, but come on, at least pretend like you're taking this seriously. And the whole refusing to answer questions thing, that's just pure ego. They think if they acknowledge the judge's authority for even a second, their entire fantasy world will collapse. But newsflash, that's not how the law works. The case isn't going to magically disappear just because you refuse to engage with reality. What do you guys think? Should judges even waste time arguing with these people? Or should they just start handing out contempt charges the second they start their nonsense? Let me know in the comments and let's dive back in.
Why are you forcing me to say answer?
Because I'm running the courtroom and it's the way I want to do it. Do you have a jurisdictional argument you'd like to make today?
I do, yes.
Then make it. What's your jurisdictional argument?
I'm presenting myself. So I need to know, Article 6 of the Constitution grants me the right to know what jurisdiction is this court operating up under?
State of Michigan.
No, what jurisdiction?
State of Michigan.
Okay, what jurisdiction is the state of
District
Michigan?
courts are legislative courts. That means they're created by statute. The state of Michigan gives me my jurisdiction.
So, okay, is that
I work
criminal
under the authority
or
of the state of Michigan.
what is it, under what jurisdiction? There's two different jurisdictions under the Constitution. You have admiralty and common law. So I'll need to know.
This is not admiralty.
What is
And
it?
it's not common law.
Which
It's
one?
statutory.
Okay, so it's statutory, that is what, civil?
No.
So what is it? For the
My
record, I need to
jurisdiction
have
is
it
both
on-
civil-
I can't defend myself unless I have it on the record. Is it,
My
it's
jurisdiction.
only two?
Sure, shut up. If you ask me a question, I can't answer while you're talking.
Okay, cool.
My jurisdiction is both civil and criminal as provided by the statutes of the state of Michigan.
Okay, so today, under which one is?
This is a criminal case.
Okay, right, so is that common law or admiralty?
It's statute. It's neither common law or admiralty.
It's one or the other. It don't say statute.
All right, then you can appeal my ruling. My ruling is it's neither admiralty or common law.
So this is you say it's criminal for the record.
Yes,
Okay, and if it's criminal, in order for a crime to exist, there must be an injured party for the record, right?
there must be what?
An injured party.
Yeah, it's the
A
people of the
corpus
state of
electi.
Michigan.
All right, so if the people of the state of Michigan, right? Where's the sworn statement?
Where's what?
A sworn statement. I have a right to see a sworn statement saying I injured someone.
There's a complaint in the file.
Sworn complaint, signed,
You want to see it?
affidavit, sworn affidavit.
No, it's not. I don't think it's an affidavit.
Well, okay, so
You said you wanted a sworn complaint.
from an injured party.
This dude really thinks he just cracked the legal system with some middle school level argument. Like, bro, do you think courts have been running for centuries without figuring this out? The state is the injured party because crimes affect everyone. That's how laws work. And the fact that he thinks someone has to be physically hurt for a law to be broken? Come on. That's like saying I drove 100 mph through a school zone, but hey, nobody got hit, so no harm, no foul, right? It doesn't work like that. Laws exist to prevent chaos, not just to punish people after the fact. The whole no injured party, no crime argument is so played out. It's literally the sovereign citizen go-to script, and every time they try it, judges just shut them down like clockwork. These people are so obsessed with thinking they're above the system that they refuse to accept basic reality. What do you guys think? Is this dude actually this clueless, or is he just trolling at this point? Let me know in the comments, and let's jump back in to see how much worse this gets.
Who have I injured for the record?
The state of Michigan
How can I
are
injure
bringing
the
the
state?
charges.
How can I injure the state?
Sir, sit down. Sit
I prefer to stand.
down.
I'm not.
Sit down, or I will hold you in contempt.
Another threat. Wow.
You're probably going to hear more than one.
I see.
All right. I am ruling that I have jurisdiction. You are free to appeal that to the circuit court. Proceed. Do the people have a witness they'd like to call in the exam?
Yes, Judge, the people are prepared to move forward. Just as a quick preliminary matter, would request a mutual order of sequestration with an exception for the OIC.
All right.
So again,
I'm not asking you to talk. Ma'am, are you a possible witness in this case? Okay. All right. And would you mind putting your name on the record, please? Counsel, I want to look at the lady. Would you mind putting your name on the record?
she's a witness. She is a witness.
Sir, you speak again when I haven't asked you to, and you're in contempt. And we'll deal with that first. The reason I need your name is because if you appear somewhere down the road and want to testify, we have to know that today you were in the courtroom. And I can't do that by taking a picture of you. So I'm asking you to state your name.
Your witness. Yes.
Sir, you are in contempt of court. That's a $100 fine. Speak again when it's not your turn, and I'll continue to up the ante. Clear? You can speak now. I've asked you a question.
I object.
I don't give a shit if you object. Is it clear what I said? I'm waiting for an answer.
I said I object. What am I supposed to say?
I want to know if you understand you've just been fined $100 for contempt.
I don't understand.
Okay, well, you still owe me $100. Are you going to give me your name?
No, you still out.
That's fine. Thank you. Witness.
Your Honor, the people called Officer Steppen. Oh, I'm sorry. One last quick preliminary matter. Pursuant to 76611D, we'd like to introduce a certified registered of action in regard to this individual being a previously convicted felon.
I object.
Hold on. Have you showed that to him?
I object. I object.
What's your objection, Mr. Michaud?
My objection is that I am here under the guise of
Bless you.
probable cause conference. And I don't know how we're here at a preliminary exam when I did not waive any right to waive a probable cause.
This is a preliminary exam.
This is okay. So right here,
This is the probable cause hearing.
It says it's
All right, stop. Right now, the question on the table is you've objected to admittance of that document. I want to know what your legal objection is.
I'm also objecting.
What is your legal objection?
To not waiving my probable cause hearing.
Denied. That's admitted.
Judges like this are exactly what we need when dealing with sovereign citizens. You can't just let them run wild in a courtroom, wasting everyone's time with their fake legal theories. Firmness, sarcasm, whatever it takes to shut them down and keep the process moving is completely justified. And for the people in the comments saying the judge is too offensive, really? What do you want him to do? Politely ask the sovereign. Citizen pretty pleased to follow the law? These guys don't listen unless you put them in their place. If you let them go unchecked, they'll keep pulling their nonsense and wasting even more taxpayer money. At the end of the day, the law is the law. If you don't like it, good luck trying to argue your way out of it with some YouTube legal degree. Let me know what you guys think. Should judges be even tougher on these sovereign citizens? Or do you think this level of handling is perfect? Drop your takes in the comments and let's get back to it. Because I just know this guy's about to dig himself into an even deeper hole.
Under what grounds am I denied not?
Because you didn't give me a valid objection.
I object.
You can't just object. You got to explain with the valid objections to the evidence.
That we are having a preliminary exam when I haven't had a probable cause hearing and I did not.
They're the same thing, Mr. Michaud.
It's still on this.
Mr. Michaud, they're the same thing.
But it's still, I have a right to a probable cause. Am I right or wrong?
Sure, try.
Am I right? Do I have a right to a probable cause?
That's what today is scheduled for.
But today it says preliminary exam. Right here it says probable cause conference. And today is a different date that says a preliminary.
Have you ever had a grilled cheese?
If it was different.
Have you ever had a grilled cheese?
If it was different, why would it have two separate
Have you ever
columns?
had a grilled cheese?
I object to any of that. Why would it have two separate columns?
Take him out.
Why would it have two separate columns?
I'm not playing this game with him today. If you think you can get him to shut up long enough so we can have our hearing, we'll do it. But I'm not going to let him try to run my courtroom.
Okay, I'll just be very brief in my one attempt here. I would like to try to explain what I understand Mr. Michaud's objection to be, and what I have also represented to him regarding that objection. Mr. Michaud, I think the court record will reflect, had a probable cause conference first on November 29th and then again on December 20th. I have disclosed, I mean, I think I've been very transparent with Mr. Michaud that probable cause conference is a bit of a misleading name because probable cause conference under the court rules does not require that probable cause be established.
Right.
At the second probable cause conference, Mr. Michaud was caring for a sick relative, so he wasn't able to attend that probable cause conference scheduled December 20th.
Which didn't hurt him at all.
Right. I represented him on that day, and I asked the court to waive his appearance so that he could remain with his family.
Which we did.
Understood to be his wishes. I may now understand differently that I misrepresented him in some way, but my goal was just to be able to conduct a probable cause conference where we were going to find out if there was any offer, whether discovery.
You don't have to tell me what they are. I know what they are.
I know, but I'm just trying to explain.
And I'm trying to explain it to him too, but I'm not going to talk over him.
Right.
And I'm not going to play that crap today.
Right.
So if you want me to explain what's scheduled today versus what was scheduled last time, I'm happy to do that. But you got to be quiet while I'm talking. Clear?
Oh, dude, I hear you.
All right. The last court date that we call a probable cause conference is like a pretrial on a misdemeanor. It gives the parties a chance to discuss the case and see if there's any resolutions prior to the next step. Next step being preliminary exam. At the preliminary exam, the people have to prove to me that there's probable cause to believe that there was a crime and there's reason to believe you were involved. That's what's scheduled today. That is a probable cause hearing. Probable cause conference is just a name that we all came up with instead of saying it's a pretrial for a felon. Do you have any questions based on that?
At what point did I waive it? If it's a hearing, or
you didn't
right,
waive it.
so
There's nothing to hold.
Do I have a right to have a probable cause conference?
No.
What?
You can do that right now. Do you want to make a deal with the people?
I want to be able to prepare myself for the probable cause conference.
There's no preparing for a probable cause conference. It's a conversation.
It still takes preparation.
You want a PCC? Go out in the hall and have a PCC with the unrepresented defendant.
Judge, just for the record, there will be no offer at this stage.
There's your PCC.
The grilled cheese moment absolutely killed me. The judge was just sitting there thinking, how do I explain this in the simplest way possible so even this guy can get it? And somehow, even that wasn't enough. Like, this is not some high-level legal strategy session. It's literally just a basic step in the process. But no, this dude is acting like he's about to argue a Supreme Court case when he clearly doesn't even understand the fundamentals of criminal procedure. It's painful to watch. And honestly, I think you're right. It's probably a mix of both him being genuinely clueless and trying to play dumb in the hopes of weaseling his way out of this. But newsflash, judges see right through that nonsense. He's not some legal mastermind pulling off a genius move. He's just making himself look even dumber. What do you guys think? Is this dude actually this lost, or is he just acting? Drop your thoughts in the comments, and let's dive back in, because I know this is about to go off the rails.
Now, do you want to plead guilty? Do you want to have an exam? And at the exam, he's got to prove to me those two things I just said. Probable cause to believe a crime was committed on this date and reason to believe that you were involved. Do you want to have that hearing so he gets to prove his case? Or do you want to waive? That's the other option. You can waive the preliminary exam and we'll take the case directly to circuit court level 2 weeks down the road for an arraignment on information, which I would describe as another pretrial on a felony, where you and the prosecutor can discuss the case, see if there are any offers. That's another option. Would you agree with that assessment, Mr. Sullivan?
I would agree, and I would also just add that Mr. Michaud has made his arguments today, he ruled on his arguments, and that he preserves his right to—
He can appeal them.
As you've already said, at circuit court. And so if he wants to sort of move forward on that defense alone, that the waiver does not preclude him from
not at all
arguing jurisdiction at the circuit court level. But likewise, if he holds a preliminary exam today, holds the people to their burden, he also maintains the right to continue his objections to jurisdiction, to appeal the court's orders regarding jurisdiction at that next level, at the circuit court level, assuming that the people are able to prove probable cause today.
Now, do you want to have an exam today?
Well, I wanted to address some, I served the court some notices.
I haven't read any of that because you were represented by counsel.
No, I wasn't. I don't have any contract.
As far as I knew, you were represented by counsel.
Okay, so now you know. And I served the court notices. And I would like to.
First notice, what would you like to put me on notice about?
Well, I served you notice that I requested the criminal bonding information. I requested
Criminal what?
bid bond.
Hold on.
I requested the bid bond, the performance bond. I have an affidavit.
There is no bond.
There are bonds. This is
okay, listen. You can't tell me something and then just disagree with me and think. Listen to me, sir. I am not going to let you interrupt me.
Oh, you just interrupt me.
I'm in charge. I get to do shit you don't get to do. It's part of the black robe. Okay, that's just the way it works. My courtroom. I get to decide how it's run.
At this point, Judge Oakley deserves a medal for patience because this hearing is dragging on way longer than it should. Like, why do sovereign citizens always act like the courtroom is their personal seminar on made-up laws? Bro, this is not a Q&A session. It's a legal proceeding. And honestly, I'm with you. How do these people function in the real world if they struggle this much with basic legal concepts? It's like they choose to misunderstand everything just to be difficult. Either that, or they really do have some kind of delusional disorder where they genuinely believe they're nonsense. But yeah, if this dude interrupts one more time, I wouldn't. Blame the judge for tossing him in jail for contempt. Some of these guys only learn when they get a real consequence. And honestly, a night in lockup might be the wake-up call he needs. What do you guys think? Is this judge being too patient, or should he have shut this down a long time ago? Let's get back into it and see if this guy finally learns to zip it, or if he's about to get a free trip to county jail.
There are no bonds required for me to do what's scheduled today. I've been doing this 25 years. I've never had a bond.
You have a bond.
Okay, I have a bond.
Everyone here has a bond.
Not in any definition I know. So let's get to the point. Do you want an exam today?
No, I really want to address. Okay, so
I'm not addressing any of that crap you got in front of you.
Well, since you say you don't have a bond, can you express that in a via affidavit so I can have a?
It's on the record. Order a transcript. I'm not signing anything for you.
Okay. Also, I want to also address that. I sent a affidavit of fee schedules for violation of any of my rights.
There are no fee schedules.
Well, I gave you notice, and
great. Then you gave me notice. Doesn't change anything. We still scheduled for an exam today.
Yes, just put it on the record that I served you notice. Okay. Also, I served you notice on my power of attorney.
Okay, you said that.
Right, and
move on.
You haven't responded to that, as well as my indemnity bond, which separates me, and I have a private capacity. I am not the artificial person.
I don't recognize any of that.
United States citizen. I am actually
hold on, stop. You can put on notice what you sent the court if you want to make a record of that. But I'm telling you, I don't recognize any of that stuff you're talking about. I don't recognize that you're not really Frank Michaud. Okay, I understand that's what you're trying to argue, but I don't recognize that.
Under what law could you represent, or you can use, tell me that, not just from what you say, because ignorance of the law is no excuse for you or nobody else. So what you're saying just don't mean nothing. I need to have facts.
Okay, well, it does mean, hold on. It should mean something because.
Prove it, please prove it.
Can I prove what?
Prove that I am the artificial person.
I can prove you're Frank Michaud.
I have full faith and credit.
I can prove.
Okay, so.
Hold on. You've asked me. I can prove you're Frank Michaud. You know how I can prove that? Because when I called the case and said you either come up here and be Frank Michaud or you leave, you came up here.
And
you proved it for me.
You threatened me.
But if you're not you, the threat means nothing.
It doesn't mean nothing.
Okay.
But you still threatening me, and you're using it under color of law.
Okay, listen.
And plus,
listen to me, Mr. Michaud.
You have.
I've wasted too much time with you. Yes or no?
So,
sir, don't argue with me. Yes or no? Are we doing a preliminary exam today? Yes or no?
I object. I will address.
Answer the question.
I want to address other issues as well.
You're in contempt of court. Put him in jail.
For what?
For contempt of court.
I'm having.
You can appeal that too. Sentence is 30 days. See you in 30 days.
And just like that, the guy gets 30 days. No surprise there. Honestly, if this doesn't wake up every wannabe sovereign citizen, then nothing will. If you're stepping into Judge Oakley's courtroom thinking you're about to outsmart the entire legal system, you're in for a very rude awakening. Like, dude, just hire any lawyer. Doesn't even have to be a good one. Just someone who actually understands real laws instead of wasting time with these make-believe legal loopholes. This guy really thought he was cooking with his arguments, but all he did was slow roast himself into a jail sentence. And that ending? Chef's kiss. Judge Oakley straight up laid it out. You showed up when I called your name, so yeah, you're the guy in the case. Like, come on, bro. You really thought you had something there? The arrogance is unreal, and now he gets to reflect on it from a jail cell. I don't feel bad for him at all. The law isn't a suggestion, and these judges aren't here to entertain. Delusions. Maybe next time, sovereign citizens will finally get the memo that their YouTube law degree isn't gonna save them. What do you guys think? Was Judge Oakley too harsh like some people in the comments were saying, or was he 100% justified? Drop your thoughts below, and if you're enjoying this breakdown, make sure to like and subscribe. Every bit of support helps the channel, and I really appreciate every single one of you. Thanks for watching, and as always, take care, everybody!